In terms of a quick background about myself, I am a European and UK patent attorney, and I actually come from an in-house industry background. I spent many years as as European Patent Counsel at Cadbury Schweppes, then Kraft Foods and Mondelez. And during my time in-house, I was responsible for negotiating IP clauses and advising on IP issues in relation to collaborations with universities. And so, yes, I was that irritating person on the other side who wouldn't accede to any of your demands and who bullied you into submission to accept our demands. But I'm now poacher turned gamekeeper, and I do advise quite a number of university clients on IP issues relating to licensing agreements. And my background as an in-house counsel on the other side, I think, helps me with giving advice on what other parties are likely to want and where the red lines are in terms of pushing them too far or not. In this session, we're not going to go through the mechanics of a license or an IP contract because that's far too much detail and would take far too much time. So it's going to be directed more towards going through some of the major issues, hopefully stimulate some thoughts on how to approach amicable solutions during licensing or IP transfer negotiations. If you do have any questions, by the way, there's a chat box. If you can just ask your questions there, I will save them all till the end and then answer any questions that you have. So firstly, it's in the title, and it's probably the biggest issue around any collaboration with industry. What is it that industry actually wants in terms of IP whenever you try and negotiate with them? Well, the almost flippant answer is that it's always going to want full ownership of any IP, which forms the basis of any collaboration. And this is going to be true in some cases, and it might be the first request in negotiations. People do ask for complete ownership. I know that when I worked in-house, that's what we did. We asked for ownership as the very first best position. If the other side has ownership, so the industry partner's ownership, they're not going to have to worry about ongoing licensing issues, interpretation of licensing clauses, and they're going to have full control over the IP. If it can't have ownership, then exclusivity of that technology is almost certainly going to be the red line. They're not going to go ahead if you don't offer them some sort of exclusivity, and it's absolutely essential in most cases. This is to stop competitors from immediately taking advantage of your industry partner's investment in the technology. Generally speaking, the bigger the industry partner, the more likely they are that they're not going to accept anything less than exclusivity in its technological field that it works in. So without this sort of ownership or exclusivity, in reality, an industry partner is going to struggle to convince its own management team and ultimately its shareholders who are paying for it that it's worth spending large sums of money or even moderate sums of money on developing products or processes that could ultimately end up in the hands of its competitors who haven't paid for that. And so they're likely to walk away from potential collaborations. So exclusivity is something that you are probably going to have to agree to in the vast majority of any IP license negotiations. Now, how far and wide that exclusivity goes is a different matter, but there's going to be some components of that. Industry will also want some degree of freedom to operate of any new innovation. So by freedom to operate, they're going to want to know that if they use that particular technology, they are not going to get clobbered with a patent infringement action as soon as they put it out of the door and onto the shelves. And although freedom to operate searching, so patent searching, regulatory searches in some cases, is generally undertaken by the industry partner, it can actually be really, really useful to show that you've done some freedom to operate searching beforehand, because if you can show that you have found no initial issues, no particular patents that are of concern in relation to patent infringement for that technology, it's going to really, really help you get that foot in the door in the first place, or convince that industry partner that it's worth moving on to the next steps in negotiations. And again, the number of times that universities came to us with freedom to operate searches having already been completed was really, really low. But when they had done, and it was done very well, generally speaking by their external patent counsel, it really did help us as the industry partners to say, well, actually, you've got past that first step. We know that if we do take this technology on, we're not going to have to spend endless time and effort trying to do that searching ourselves. And so we're more likely to deal with you. What does it not want is the next point on the slide. Well, it absolutely doesn't want its resources, its money, its time being wasted on a collaboration which can be picked up and handed to its competitors on a plate. That's generally non-exclusivity. If you're trying to offer them non-exclusivity because you think that you can hedge your bets and license it to other partners, other collaborators in very similar fields, the chances are that you're not going to license it at all, because most industry partners are going to realize that it's just a hiding to nothing. Sometimes this can be, though, due to the fact that the technology being licensed isn't actually protectable by any form of IP. So, for example, it's not protectable by patent, and it's not something that can be kept confidential or secret and be used as know-how. In those cases, industry is going to be really, really shy of actually entering into any license agreement, which means that they're not really going to have any control over that particular technology. And finally, it doesn't want to spend endless time negotiating early stage research. With really early stage research, if there's a lot more research that needs to be done in order to actually commercialize that product or process, the industry partner, is going to be taking all of the risk effectively, and it will expect exclusivity to be agreed very quickly, and possibly ownership, depending on how important that technology is to both parties. So you've always got to consider what industry wants in terms of what it's actually doing, its commercial aims and its commercial processes, before actually considering whether or not what you're trying to suggest in terms of options are viable. So what are the issues? Well, industrial partners make and sell things, so you've got to put yourself in their shoes. The ultimate aim of an industry partner is to maximize its profit for the benefits of its shareholders, and this is an actual legal construct. That is articles of association for any limited or public company. They are legally obliged, everybody working for that company, to maximize the profits for the benefits of the shareholders. Anything they do that doesn't do that, legally speaking, they're liable for that, and they could be clobbered. But in order to do this, it generally needs to ensure that its competitors can't ride on its coattails and take advantage of its innovations or its products that it's selling. Obviously, one way of doing that is protecting its products with IP, brands, registered designs, and patents for the most part, but lots of other types of rights. The bigger the industry partner, the more likely it is to want ownership. And I know I've said that lots of times they don't really request that, but the bigger the partner, the more likely it's going to want ownership, especially if there's no university-owned IP in the background, so background IP that you can bring to the table. And especially if you don't have a patent or patent application underlying the technology that you're trying to sell or license to the industry partner. If there is some background IP, ownership of any IP generated during the collaboration, so that's called foreground IP in most agreements, it isn't necessarily going to provide much more benefit than an exclusive license anyway, because the university is going to be able to control what happens to that foreground IP through enforcement of its background IP after the license ends. So generally speaking, if you have your own patent or patent application as your own background IP, the industry partner is going to be more than happy just with an exclusive license to the foreground IP. That's one huge reason why you should always try and at least file your patent or patent application before approaching any industry partner to license any technology or collaborate to create any new technology. They're definitely going to need exclusivity in their own field. And one consideration of this is, what actually does their field mean? How wide is that? Is it just their technology, or is it fields around there, close fields, competing fields, where they might have research interests? In my experience, again, from the other side of the table, there is no point in trying to negotiate out of ownership or an exclusive license in the industry partner's core field, because they're just not going to accept anything other than that. They'll just walk away. Non-exclusive license isn't worth the time and resources, unless that technology is likely to be absolutely essential to their business, but it's highly unlikely because they have multiple products, multiple revenue streams, multiple ways of commercializing everything that they do. One particular bit of technology isn't going to impact all of those. It might impact a very small part of it. Another issue you're going to face is industry's reluctance to sign non-disclosure or confidentiality agreements. When I did work on the other side of the fence, this always seemed to cause great surprise and actually even anger in some cases when I discussed potential collaboration with university partners. But the fact is, it's not industry being arrogant or authoritarian. Really, the real reason is because they're likely to be working on very similar technology. That's why you're approaching them with your technology. They're going to have many different research streams themselves, which overlap with the technology that you're bringing to the table. And so signing up to a mutual non-disclosure agreement can cause huge headaches internally. And in particular, the thing that we always had to watch out for was that if there was any subsequent dispute between the industry partner and the university, with one side claiming they disclosed confidential information, which the industry partner is already working on, then it can be an absolutely huge headache to try and prove that they were already working on it. Easier said than done in multinationals because they have research departments in lots and lots of different countries, and so they know they're working on this research, but trying to get that out of a particular research department is quite difficult. So industry is very reluctant generally to sign mutual NDAs unless it's clear that this technology is fairly new to them and they're not going to be doing that type of research in their own R&D departments. And then, by no means least, another issue is that big industry and even small industry to an extent get a lot of proposals each year. And somebody or a team of somebody's has to deal with them. So that personal department has to triage, review, and arrange meetings for all of these potential technologies that are touted to them. And the more aggressive the proposer is, the less likely that that proposal will ever get past that initial discussion stage or get past that gatekeeper, especially if it's early stage research or requires a lot of resources. So all of these all of these issues add up to the fact that whilst not necessarily dismissing every approach where IP is not exclusively licensed or assigned, in the majority of cases, one of those two options needs to be agreed in order to progress any discussion whatsoever. So it all sounds doom and gloom for universities, but it's not. It's just the initial hurdle to overcome and ensure that money flows into the university. The next question is it worth pursuing, even if the industry partner says, yes, they're quite interested in talking to you and you've got past that initial hurdle? The key question that industry are going to ask is there a market for this technology? And it might sound strange because you've already ascertained that this technology is in the same field they're working on. And if they're working on similar solutions, then surely there's got to be a market for this technology. But it's not just a case of whether or not this technology fits into their research streams or not. It's whether that particular technology solution that you're offering has a market by itself. And an example would be, and this is a real life example from when I worked at Cadbury, an industrial partner might be working on 3D printing of chocolate to provide personalized chocolate products for its customers. But they need any solution to have low capital expenditure. So if your solution that you're trying to sell to them is to provide a three-dimensional digital printer, which creates wonderful chocolate shapes, but costs an absolute fortune to run, and the products will be very expensive and in limited quantities, whilst another university provides a machine that uses mechanical book molding with molds that can be used on existing production runs in existing factories, and which costs very little to run and can mass produce 3D chocolate products. Which one is the company actually going to choose as its preferred collaborator and enter into negotiations with? The high tech, high cost, but high wow factor option with limited commerciality, or the option they can translate easily into existing factories for mass production? And this is something you're really going to have to think about when you are discussing anything with industry. Is from their point of view, it has to be easily slotted into their existing processes, factories, product portfolios, unless it is so unbelievably good that they can actually set up something specifically for that. The next one is the research easily translatable into a commercial product? So a new technology might be cutting edge and have some potential, but if that potential can only be realized in 5, maybe 10 years down the line, industry is unlikely to want to invest huge sums of money now or pay massive license fees. Even if the eventual solution is going to require regulatory approval, sorry, if it is, what are your plans to convince the industry partner that it's worth going through that particular pain? Because again, regulatory approval of a particular technology can be just as expensive and time consuming as any other type of approval. Third one is academic commitment. So if the academic leading that particular research has a track record of not having enough time to commit to collaborations, or even worse, being very uncommunicative once they've agreed to do something, this is really going to affect the likelihood of collaboration being successful. And does the industrial partner already have experience with that academic or their research group, in which case they're less likely to commit to any sort of agreement where it's in your favor. On the flip side, the industrial partner might be really keen, and they really do want your technology, but they might be unable to provide anything other than cash, which might not be very much cash. Is that enough to ensure that any collaboration that you enter into will yield fruit for you as well as the industry partner? So you do have to look at it from your point of view as well as theirs. And one of the things is, do they have the resources or not? If they don't, it might not be worth your while. For any research that you're doing and that you might want to license, which already has a pool of friendly industry, especially industry giants, because they always have lots of resources, that can be incredibly helpful, because it means you're not likely to have to go looking too far for somebody who's interested in your technology. And again, on the flip side, from the university perspective, if you come to the table with existing patent rights in particular, but any other type of IP right that might help you, it's going to ensure that the industry partner is more likely to take notice of the idea, especially if you've got a granted patent, or you've got a patent application which has got a favourable examination report, which means it's likely to go to grant, and especially if it's in a major country, so Europe, the US, China, Japan, anywhere where that technology might be manufactured or sold. This is going to ensure that you come to the table with a position of relative strength, and it also shows industry that there's a much higher chance that exclusivity, if you offer it, can actually be guaranteed, because it's backed up with that patent or patent application, which would prevent their competitors from being able to take advantage. So preparing for the initial discussions, or I like to call it, before the first date. If you think of negotiations as some sort of dating process, and this is before you actually turn up on your first date. So how do you approach it? So everyone's going to have different approaches, and you'll be far more knowledgeable than me from the university perspective. But from an industry perspective, the following points are likely to be need a lot of consideration and generally practiced by industry. So the first one is, you need to have a position that's your optimum result before you go into any negotiations. So this could be an exclusive license yielding royalties of X%, a payment of patenting costs, plus a lump sum to do the research. That's your absolute optimum position, and you've got to expect that might be knocked down. Then you've got to have your fallback positions. So, and these have to be something that you're happy with. So for instance, it might be that you would be happy to grant an exclusive license for a smaller lump sum, and again, X% royalties if the research is commercialized over a certain volume. That might be acceptable to you, and that might be your next position. And you can have multiple fallback positions going from best to worst. Then you always have to have a red line, a walk away point. So if a potential collaborator is not going to shift on demanding full ownership, for instance, or refuses to pay a royalty and only offers a lump sum when you know full well that the major value is in ongoing sales, you have to have written down really a red line that you say, well, that's it, we're going to walk away, we don't care, we'll find another collaborator, or it's just not worth our time and effort on this. And if you don't have that, there's going to be huge issues. Nobody likes them, nobody likes red lines, and parties do fall into the trap of throwing good money after bad, or accepting a position which comes back to haunt them later on. But there's so many reasons why you should have them, and where they are, where this red line actually stands, low or high, will depend on lots of factors, where you are with obtaining IP and how relaxed you are about reward versus effort for that particular technology. In particular, if you've got existing IP, which is rapidly draining finances, and you haven't been able to find an industry partner, and a collaborator comes along, doesn't offer much, you've got to ask yourself, are you prepared to go with a less than optimal agreement to keep that IP alive, but in return for example, put the onus on the collaborator to do the patent prosecution work, to pay for the patent applications, and have maybe a shorter license agreement or the ability to do more things in the background. So there's lots of things you can do for your red line, but always have one. So your initial discussions, you got to the point where you are sitting around a table, or maybe a Teams conference call, or whatever you do these days. What should you do when you're having your first serious discussion and get to the issue of IP? So firstly, it depends whether you've already got registered patent protection, generally speaking, patent protection to an extent. If you do, then things can be a lot more open. You can disclose a lot more, and you can be much more relaxed on negotiating what happens with foreground IP generated during that collaboration. You can disclose technical details if you want, down to the minutiae, but make sure that you don't disclose technical details that aren't in your patent application, because they might be patentable in themselves, or you might not have signed up to a non-disclosure agreement for this particular meeting. You can still sign a non-disclosure agreement if required, and I would always recommend that you do, even if you do have a patent or patent application, really to ensure that if you do have technical details not in the patent application and you do accidentally disclose them, they are protected for that meeting. And discuss everything: licensing, future IP ownership, who pays, expectations of both parties. You're in the position to discuss everything in as much detail as you want. If you don't have a patent or patent application, try and insist on at least a two-way non-disclosure agreement, and be very wary if one of those isn't signed. Even if that means not commercializing the IP immediately, because perhaps that's the only potential partner on the horizon and they won't sign a two-way NDA, it's often not worth the subsequent hassle and potential disputes. And you can always come back to that potential partner later if you do decide that actually that's your only option. And based on my experience and the people I work with in multiple companies, industry doesn't hold grudges. We have we have negotiations, they fall apart. 6 months later, the same party comes back and says, do you know what, we've decided that we'll accept some of your terms. Everyone's happy and carry on. There really aren't really many grudges. And so going away and saying no and then coming back later is generally a really viable option as well. If you do have to discuss some aspects without an NDA, then make sure you don't disclose anything that could be considered the invention. So just discuss general aims, maybe general results, without saying how you achieve the results, so that the other partner has got an idea of what it is you're likely to want to achieve. You can discuss future IP ownership and some aspects of remuneration. Many academics are quite good at this anyway, because they're told to do this for poster presentations or abstracts when there is a patent application in the pipeline, but it's not been filed yet. So it's not something that some academics are going to be unfamiliar with, and it's quite easy to do. But in both cases, whatever you do, don't commit to anything during the meeting. And this is really, really important. Anything agreed in the meeting, even if it's just verbally agreed and nobody writes it down, can actually be binding on the parties during any subsequent negotiations, and even if negotiations fail, which is always an eye-opener. So you could be committed to granting the industry partner something, even if it's only verbally agreed. For that reason, make sure that you don't agree to anything. Just make sure that everything you say is, this is subject to heads of terms, subject to contract, and nothing that you're saying is a decision on the day. Also, make a file note of what was discussed and who said what, preferably while you're in the meeting. And it's amazing the percentage of meetings where intellectual property is discussed, with or without an NDA, which are never minuted, they're never written up. And it's equally amazing how often that comes back to blow up in everybody's faces. Most often it's going to be in the form of both parties claiming to have said something in a meeting, which is actually the eventual invention that's developed, and neither party admitting that, yes, it was the other party that did that. If nothing's been written down, how are you ever going to prove that? And I did once actually spend 3 weeks interviewing two parties as an impartial adjudicator, as an arbiter, to determine which party provided the input for, it was a pharmaceutical compound, which subsequently became quite a big bestseller. And it was subsequently claimed in a patent application by one party, and the other party disputed it. because absolutely nothing was written down and both parties were adamant that they came up with it, the end result was that nobody could determine whether or not the applicant who filed a patent application owned it or the other party. And it eventually went to court, and the court had to find that they should both be joint applicants because of that, which really wasn't the best result at all. So always make sure everything's minuted, send it back to the party afterwards to say this is what we discussed. So following up, deciding whether to commit to that second date. Always take a couple of days or even weeks to reflect. You don't need to respond immediately, even with requests for more information or requests for a discussion on what or wasn't agreed. Take that time to go through your checklist of the pros and cons of signing up with that particular entity, and note what position both parties seem to be happy with. Does it still seem worthwhile to proceed? Once you've got to that point and you think, yes, it still is, then discuss it with all your stakeholders, in particular, your academics, the inventors, who, if you do sign up to anything, are going to be on the front line in terms of time, resources, commitments. It needs to be a frank discussion with them because they need to really understand that they are the ones who are going to have to commit to this. And if they don't, if they're in breach of contract, then the university is in breach of contract and it can come back to haunt everybody. You're going to have to be really frank with them with how much work is required if this collaboration takes effect and whether they've got the time to do that. Ask them whether or not the industry partner, as far as they know or from what they've heard, has a track record of commercializing university IP and whether or not it's worth going forward or it's just likely to die a death with no commercial product and no royalty income. And finally, is it worth having a license, no matter how limited, to help to get more funding or with future research? So, for example, there might not be much in the way of grants coming in, but if you get some funding through a license agreement for that technology to help that academic keep going with that particular research, that might be the reason why it's worth going forward, even if ultimately the license agreement is in favor of the industry partner, as long as the university is getting enough money to pay for that research and those patent applications. And if after reflection and discussion you decide that a collaboration based on these terms is appropriate, only then go back to them to set up a meeting to agree on general principles or heads of terms. And for those who haven't come across that phrase, heads of terms is a pseudo legal document that can become subsequently binding, either in part or in total. Once that it's written down, everybody signed it. And again, ensure that any follow-up meeting or call is recorded. Agreed principles are set out in writing. Signing the contracts, entering into the relationship. So when you've got a first draft of your agreement, make sure you get input from all stakeholders on the main issues and always get legal advice on everything, including what are called the boilerplate or standard clauses. Now, these are those that typically appear in all templates. They can be arbitration clauses, termination clauses by default, jurisdiction, where to send documents to, who has authority to confirm, spend and sign things, etc. They remain unaltered or are tweaked very little before signing the contract, and most people just ignore them. They shouldn't really, but they do. Every other clause is bespoke, and you have to be really careful that you're 100% happy with them. And these could include the IP ownership clauses, which are really important. Who owns what you can do with foreground and background IP, both before and after the license agreement ends. Remuneration, what you're actually going to get in terms of royalty rates, lump sums, resources, etc. And then equally important, what happens after the contract ends. And this is particularly important for future academic research. If you sign up to an agreement where at the end of the contract, your academics are really prevented from carrying on with that particular research stream because the other party's got patents or foreground IP, which will block most further commercialization. Your academic might be able to do the research, but you won't be able to commercialize any improvements because it would still fall within the scope of the patents from the previous collaboration. So it's really important to try and iron that out. Be willing to compromise on the small stuff. So in this case, don't get bogged down with things that really don't matter. For example, we had some issues where the university wanted a particular reporting regime or mechanism and a certain number of review meetings, which we wanted to push back on because there just wasn't any time to have all these in the collaboration. It became a bit of a battleground, but in reality, it's not something that, if it's the other way around, the industry partner is ever going to flag as an issue. And it's generally just be there to ensure that both parties can request a meeting or report when needed. These clauses are they're very rarely ever enforced, and I don't think I've ever been involved in any dispute which involves somebody not having a meeting at a particular time or not, sending something by post when email was specified in the document. So things like that you can ignore to all intents and purposes. It's the big issues, IP ownership clauses, remuneration, termination, that sort of thing, that you really need to have a real think about. And ensure that academics know their responsibilities. Again, this is from the previous slide, really. They're the ones who are going to have the time and effort spent on this particular collaboration. If they can't commit to it, don't sign up to that agreement, because it's bad practice. It's only going to lead to a bad reputation for the university, and it's guaranteed to ensure that that industry partner will look elsewhere in the future rather than your university. And from my point of view, from being in-house, that was the major issue with contracts with universities, was the universities where the academic didn't have enough time to actually commit to the collaboration once it was all signed, and some of those really did end up blowing up into quite big disputes, which leads on to disputes. So relationship trouble in the dating analogy, they do happen. Big disagreements rarely happen, but and most of them are resolved either just by the parties talking to each other, or by, it's got to that point where both parties say the contract is untenable, and they both agree to terminate the contract with no further conflict. And that's the vast majority of disputes. And as I say, they're generally quite rare. When they do happen, it can be a real nightmare. It's going to eat up a lot of time, a lot of resources, and a huge amount of money. And in fact, the money spent on legal fees over contract disputes might mean that anything you get in terms of licensing income or lump sums is completely eaten up. And in some cases, if you go to court or arbitration, you're going to lose money, even if you win. And they generally happen through three areas. One is lack of progress. Sometimes there's no fault. The research just isn't going anywhere. Sometimes it's the fault of one party or the other. Second major reason is difference of opinion on ownership of IP, or one party's ability to exploit or publish. And the third one is a difference of opinion on how much money is changing hands or should be changing hands based on license fees, volumes of sales, etc. I'm not going to go into detail on what to do in relation to them, because that's a huge topic by itself. But if the worst comes to the worst and a conflict is declared, then you are then going to be resorting to what's in your contract, which is why it's important to have the right clauses in there. I put on this slide that vanilla versus bespoke. Vanilla clauses are, generally speaking, you agree to arbitration or mediation first, and then you agree to court action only if that fails. And generally speaking, that's the best. I've been in lots of negotiations where people want to change that, but it tends to result in something that's just not workable for both parties. If you then do get to the point where you have a dispute and it's going to have to be settled by a third party, you have to ask yourself, what's the best jurisdiction? So always try and ensure English law is used in both the contract and for any arbitration or court jurisdiction. If you can't, because the other party pushes back and they're not a UK company or firm or person, in order of best to worst, Northern European, Commonwealth countries or common law countries, a large commercial US state and a small commercial US state are probably best. And failing that, any non-corrupt country. But if you're getting down to that, I would recommend not going anywhere near that collaboration in the first place. And then you have to decide courts versus arbitration. Everyone would think that court action is, generally speaking, going to be a lot more expensive than arbitration or mediation. It's not. Often the case is that arbitration is more expensive because it takes longer. And I would recommend that you really think carefully, if you have a dispute, whether or not it's better just to go straight for a court action, which doesn't have to be in the High Court or the Court of Appeal. It can be in a much smaller court, in which case the costs are a lot less. So ending the agreement, the breakup, this is mostly dealt with in the termination clauses of your agreement, and they need to have everything you're ever going to want to know, including what survives, how to disentangle yourself from the contract, but they often don't, and then go back to the slide on disputes for what happens after that. Generally speaking, there'll always be a boilerplate clause where both parties can terminate if they default on the agreement. But what else should you actually include? If you're the stronger party, you can optimize in your favor any termination clauses. So for example, if you have background IP that you know will mean that your collaborator, if they try and walk away, can't go and then sell their products or use their process, which uses your technology because it will infringe your existing IP, you're in a really strong position, and you can possibly agree to better termination clauses in terms of what you can do with the foreground IP, what they can do with the background IP, etc. But watch out with this. It's quite easy to slip into the idea that you're in a strong position, you can dictate anything. But if it's too onerous, the chances are that the other party, especially if it's a big industry partner, they're going to just walk away because they know full well that you're just trying to abuse any authority there. But it works the other way around as well. When the contract's finished, but there are loose ends, such as ongoing research, or the university has a need to publish once the collaboration has ended, it's essential to ensure that termination clauses allow for all of these scenarios. Otherwise, you're going to be at the mercy of arbitration, the courts, or a potentially protracted series of meetings with the collaborator, which could still result in arbitration or court action. If there's anything not in the termination clauses, but something crops up, just have a pragmatic view and look at it from both sides of the disagreement, compromise whenever possible to enable you to move on at the end of the agreement. What I would suggest is if you've had a good agreement, a good collaboration, you've got the money, you've got the industry partner on side, and termination happens for whatever reason, and minor disputes appear, often the best policy is just to agree to disagree, agree to any minor concessions and move on, because you'll still have that industry partner on board. They'll want to deal with you again in the future, and you've not lost too much. You've gained all that goodwill, you've gained all the money from the licensing income, etc. And then finally, decide on any immediate publication needs. Obviously, if there's foreground IP that's been part of this collaboration, but it's not yet been published as a patent application, you might need termination clauses which allow the university to publish in academic journals or otherwise, even if that patent application hasn't published. But again, a lot of this is standard clauses that most industry partners understand that they're going to have to accept when they deal with a university. Post-agreement issues. What are you going to do with your old flame stuff once the agreement is over? Try and ensure that if you own the IP, at least the background IP, that the break is clean, so nothing is outstanding and you're left to walk away and do what you want. Especially you're left with unlicensed background IP that you can then use with other parties in the future without fear that you're going to somehow breach a clause that survives termination in the agreement. Often the parties are going to agree to a semi-clean break. The industry partner might want to be able to use your background IP for products that were developed during the collaboration, but not for new products. And that could include even tweaking the products that were made during the collaboration. And that's so they can avoid business disruption. And often you're going to have to agree to that. Otherwise, you won't sign the agreement in the first place. The parties might agree to a semi-clean break in order to negotiate a new agreement. And then on the other side, the university might be allowed to use the foreground IP that was generated for non-commercial purposes or for research that might result in further IP. All of these things need to be discussed before you sign the agreement, but make sure that they're there so that once the agreement's ended, you can do these things if you wish. I've also put something here about accrued liabilities, which might not end even if you have termination clauses. What does this mean? So simply put, any liability in terms of time, money, resources, help with infringement issues. So for example, if a patent is filed, which is the result of the collaboration, and the industry partner owns it or has an exclusive license and wants to sue somebody infringement, your accrued liability might be that you have to spend an inordinate amount of time giving evidence providing documents and being there during that IP dispute. If you don't want to do that, you've got to make sure that that's in the agreement before you sign it. Very often, though, your industry partner is not going to accept that because they will want that help once the agreement ends. Just check that everything isn't too onerous. It's always the case of you have to be quite pragmatic and quite practical on this. Should the licensee have a run-off period to sell its inventory? So that, again, that's to do with the background IP. If you have background IP, which would effectively mean they infringe your background IP after the agreement ends, if they continue to sell products which were the result of that agreement, are they able to do that? Generally speaking, yes, they should be able to. But what you agree should be tailored to how valuable it is and what you might want to do post-contract yourself. And then finally, this has been a quick run through, but a few tips. So the first point is just to say, if you're too aggressive, demanding or forceful, and this is the same on the other side, of course, or negotiating in a way that irritates the other side too much, it's likely to be met with a refusal to deal. And the bigger the company you're dealing with, the more likely that's going to happen. Not getting that extra concession, that extra 1% royalty rate or the extra IP right might not be a big issue if the prize is huge, but having a deal collapse because of your refusal to back down is, and 0% of a potential fortune is still absolutely nothing in the grand scheme of things. On the other hand, getting less might stick in the throat, might seem unfair. After all, it's your academics who and the university's resources that might be the bulk of the collaboration, but real world economics rules. And getting less of a loss is still a win and potentially a springboard for greater things. So sometimes accepting, a smaller license fee or smaller amount of remuneration, even if it doesn't seem particularly fair, if it still gives you a lot of money and it's going to give you that ability to showcase your technology and to lead to better negotiations and better collaborations in the future, it's probably worth doing. If you've got a potentially great bit of research or IP, but you're stuck without a licensee and are becoming, I hate to use the word, but desperate, or thinking of simply accepting that no income is going to be possible for that research, just consider whether or not there is an absolute minimum that you would accept. So that might be, the industry partner pays for patents and IP, and that's it. Or it might be that they pay for patents and IP with more favorable terms to you in terms of exclusivity. So it might be that you can license it to other people in the future in slightly closer fields to theirs, or again, it might be that you accept that there's not going to be a lump sum or royalties initially, but once it gets over a first sales hurdle or volume hurdle, you get more at that point. There's lots of different things you can do to make sure that an agreement is signed, you get enough to pay for what you need at that particular point in time, and worry about the future in terms of how much you get later on. Another thing is to invest in training academics in basic negotiations in industry. I would say that the more academics know about how to go about dealing with, in particular, contracts people, lawyers and patent attorneys who are working in industry and who are likely to be in the meetings with them, as well as the R&D folk who they already deal with, the more likely they are to help rather than hinder during negotiations, because they'll understand it from the commercial point of view as well as the academic point of view. And they're more likely to see the commercial implications from the industry perspective and temper their own expectations on what they're going to get out of this for the university and for themselves. And then finally, probably my biggest tip is don't ever sit on non-working IP for too long. Patents and patent applications in particular, but all types of IP, are a ravenous, hungry beast that eats cash like nobody's business. Causes arguments with academics whose baby it is. If you file patent applications, I'm sure many of you will have got this scenario where you're trying to get rid of it and the academic says, but no, this is, and they're a head of department or a dean, and they won't allow you to get rid of it because it's their baby and it was their big bit of research, but it's not generating any money. And it takes up too much time as well. So one of my key points of advice is just make sure you're having regular portfolio reviews and pruning as much as possible in order to release those bits of IP that really aren't going to bring you any income whatsoever and release funding for new ideas. And that was it. That was our whistle stop tour for today. So if you do have any questions, please feel free to put them in the chat and I'll try and answer them. And if not, I'm always available by email afterwards to answer any questions you might have afterwards. But thanks for listening. Okay, looks like no questions at the moment. So as I said, if you do have any that you can think of after the event, then please feel free to email me or give me a call and I'll try and help out. Oh, we might have a question. So somebody commented that they're often under pressure from academics to accept a less than optimal deal because they want to collaborate and produce publications. Well, that does run into the issues that we discussed there, which is you have to look at the technology, how valuable that's likely to be both now and in the future for the university. If it's technology that's really early stage research and it has to be published there and then because the academic needs to publish it for their own reasons, obviously, you do have to take a pragmatic view there, which is, well, is it the sort of technology that is likely to be commercialized by big players and you're likely to easily be able to license it? If that's the case and you have to collaborate and they know you have to collaborate, then yes, you're likely to have to accept a less than optimal deal. But at the same time, you can minimize the risks there by filing the patent application beforehand. Even if it's a very speculative application, it still gives you that background IP, which you're taking to the table, which might help to stave off some of those less than optimal clauses that the industry partners are likely to want to put in there. And you can use all of the other tools that I mentioned, getting the other party to pay for patent applications, getting money in some other sense, whilst leaving yourself open in the future to potentially do other deals. But yes, it is a chicken and egg situation. Academics want to publish. They've got somebody in mind who might want to collaborate with them, and time is of the essence. And I think all you can do is go through this sort of checklist of processes, your optimal result, your fallbacks, your red line, and train the academics to ensure that they know that sometimes things aren't going to happen and they might have to pull their publication or delay it for a certain amount of time. Okay, I think that will be it. Thanks very much for everybody for attending, and hopefully I will see you at the next webinar, which we should be sending invites out to in the next few days. Okay, thanks everybody. Bye.